Jerry, earlier on we were talking about your family and your children, and you mentioned that John, your son, practices law with you now.
Yeah, John's he's 43, and he went to the University of Virginia undergrad and UT Law School. And when he got out of law school, he started with me. It's the best thing that's happened in my law business. A lot of father-son firms don't get along too well sometimes. I've seen that. But if I didn't have John, I would just have to quit altogether. Of course, I'm kind of semi-retired. I'm doing a lot of mediations now. But John's a real good lawyer, and he works hard, and he's straight down the road. Judges listen to him, and he's just been the savior for me in the law business. Got a young lawyer with me named Mark Free too, who's very good. Now Leslie, my oldest daughter, is with the Nature Conservancy, and fortunately they've stationed her here. That's an environmental organization, you know, and she's working on a project they've got on the Duck River. And of course my son Drake, who's about 40 now, he has the Crown Liquor Store on the highway. He went to the University of Alabama, but Drake never really applied himself. But he's got a great business now, so I'm proud of him. And as I told you, my daughter Sarah, she got married last October. She is a lawyer with CNN in Atlanta. She just started with them 2 years ago. Prior to that, she had graduated from the University of New Mexico Law School and got her undergrad at the University of Oregon. I want you to know I have paid college tuition at 10 different universities. 10. I can name them all, from Baylor to Wake Forest to Virginia to North Carolina to New Mexico, Oregon, Alabama, Vanderbilt. It just goes up. Murfreesboro this last week. And my boy in Murfreesboro, Jerry Jr., he just got, as I told you, he just got his master's in history, and he wants to be a teacher.
Fantastic.
Make a great lawyer. He really would, but he's not a bit interested. So that's where my 5 are right now.
You mentioned that practicing with John had been a big thing to you and something you really enjoy. Tell me, you've been practicing law, you said a while ago, a little over 50 years. Mm-hmm. A lot different now than it was when you started.
Oh, my, yes.
Technology, of course, is remarkably different. How has that affected the actual practice of law, trial practice?
Well, I'll back up a little bit. The real thing that's affected the trial practice, civil and criminal, is what we older lawyers call the new rules, the rules of civil procedure and criminal procedure that were went into effect, I think, in 1972. See, now, if I started practicing in 51, I'd been practicing 20-something years before we had the new rules. Then, before the rules, you didn't have any interrogatories, you didn't have any discovery, you didn't have to tell the other side who your witnesses were. You didn't have deposition. You couldn't take the deposition of the other party or the witnesses. I mean, it was a trial by ambush. And believe you me, that was fun. I promise. Because the other side, unless you happen to tell him or he happened to discover some way, the other lawyer, he wouldn't know your witness or what your defense was or anything other than what's in the pleadings. But see, when they put in the new rules, you have to start answering interrogatories and go to depositions, and it just goes on and on and on. It's not near as much fun as it used to be.
It takes a little bit longer to get it done, too, doesn't it?
Oh, yeah, and then it's more expensive to the client. And then you get a lot of these young lawyers coming out of law school, and boy, they just will load you down with motions and interrogatories and just keep on going. So it's not like it used to be. And then the technology, you know, especially in criminal cases. The technology today has helped the state prove cases, get guilty verdicts that they wouldn't have been able to get 20, 30 years ago, you know. Today, the criminal case, and I guess civil cases too, I do about half civil. A criminal case you could try today in 2 weeks, you'd have tried in 3 days back in the 50s and 60s. And you know, it's this is a bad thing to say. It's a lot more expensive to the clients now. It used to be lawyers did not cost what you pay today. Back when I started, they did not.
Do you find that more cases settle now than used to, or has that changed much?
I think more cases, of course you've got a bigger volume. Definitely more criminal cases settle on pleas now. No doubt about that. And I think civil cases more settled. Mediation is going to be the coming thing, Paul. I mean, that's no doubt about it. I'm a Rule 31 mediator now, and I've had in the last year I've had about 40 cases in the last 18 months. Settled nearly every one of them. If you ever get the clients together with the insurance adjuster or whatever the parties are, and if you've got lawyers that are anywhere close to reasonable, you'll settle the case. And our judges today can order mediation, and they ought to do it more than they do.
What about the lawyers today, as opposed to when you started or over the years since you've been practicing? What the quality of those of us at the bar?
Well, the worst thing that's happened in the law profession is allowing advertising. You know, the law is a profession, and it's not a business. And lawyers should not be able to advertise. Their success should be based upon their reputation and what they do. Because you can now have lawyers that are advertising as being experts or very good in certain fields, and they may have just gotten out of law school. I mean, there's no control. Because of that, I think our ethical standards are lower than they used to be. They are abused more. Back when I started, we didn't have a board of professional responsibility. That's one of the best things that's ever taken place in Tennessee. Now, I was on the board from '84 to '90. Every lawyer who has any regard for his profession should serve on the board 2 or 3 years, I promise, and you'd find out a lot. I think because of all of this, we don't have as many what I call real quality lawyers. We've got a lot of quality lawyers. We've got a lot more lawyers than we used to have. But a lot of them out there, Paul, don't care about anything but, and I'm not attacking or criticizing their profession. We have some out there that don't care about anything but making some money. It's a business. Churn it out.
You have a tremendous number of friends at the bar, and I know that because I've known you a long time. How do you retain those friendships in such an adversarial life that we live?
Well, you retain it by being civil and not being rude. I don't want to get into religion. I'm a big Methodist, but you know, my idea is there's all kind of controversies in religion, but there's really only one rule to follow, and if you follow that in the law practice, you're not gonna have any enemies. and that is do unto others as you would have them do unto you. Now, that's what Jesus said, and I'm not, I'm religious, but I'm not fanatic. I like to take a drink and all that, bet on the horses, all that stuff. So, but I have tried to follow that, and in the courtroom, you can really get wound up and jump on some witness. Sometimes you have to get after a witness. You have to cross-examine just as hard as you can and bring up some stuff that maybe the other side doesn't like. But you should be able to walk out of there. And me and you, though we've hit heads hard, real hard, walk out of there and be friends. Mm-hmm. As long as you know that I'm not going to mislead you or do something that you feel you've been mistreated. My big experience with that is when I started. I hadn't been practicing law 5 years. Mr. Hugh Shelton represented the L&N Railroad.
Mr. Hugh Sr.
Hugh Sr. He's dead now. He's old enough to be my father. Great big man. Great lawyer. Real good lawyer. This is back in the 50s. And he represented L&N Railroad. Well, back in the 50s, if you represented L&N, you had a real good client. And, I represented a fellow, the train hit at a crossing. He was driving a dump truck. And I think he actually hit the train. I didn't have much case. And we tried it. And back then, in the courtroom, the circuit courtroom, the jury box was in front of the judge's bench. Not at the side, in front. So when you were arguing anything to the judge, you were arguing, looking at the jury and looking at the judge at the same time. Well, he put the engineer on. Well, the engineer's a union member. And the engineer didn't care a hell of a lot about the L&N, And he wasn't testifying like Mr. Shelton wanted. And Mr. Shelton got to lead him because he's witness. And I objected to the question and the answer or something, I guess the form of the question. And then we got in an argument about what the witness had said, what the question was and what the witness had said. So Mr. Shelton and I were standing up side by side in front of the jury, in front of the judge's bench, Judge Ingram. And I was saying he said one thing, and Mr. Shelton said he said something else. And then Mr. Shelton, I said, no, he didn't say that. And Mr. Shelton said, you calling me a liar? And with that, he hauled off and hit me in the side of the jaw here and knocked me about as far as the bookshelf over there, right in front of the jury who I could have reached out and touched. Well, of course, Judge Ingram liked him. And as you know, Judge Ingram, he was hard to upset. But boy, he got mad. He sent the jury out and he got on to Mr. Shelton. And Mr. Shelton was a real gentleman. I mean, always something snapped. He just lost it. But anyway, we finished the case, and I got a judgment, I think, from my client for $5,000 or $6,000, which is okay back in the 50s. I think he had a fractured leg. We were walking out of the courtroom, and one of the jurors whom I knew walked up to me and said, well, Colley, I'll tell you one thing. You weren't going to get a damn thing till Mr. Shelton hit you. And do you know, Mr. Shelton and I he graduated from Vanderbilt Law School too. And we became big buddies after that. But
your reputation amongst lawyers that I know, and I refer to it as a tabletop lawyer, that you beat my brains out, but you'll do it on top of the table. You won't stick any knives in anybody's back. You don't, you'll take advantage of every available little trick here, but you won't mislead, and you don't go where you don't need to go.
Well, thank you.
Have you found that to be beneficial or hurtful to you in your relationship?
Oh, it's so beneficial.
Winning lawsuits,
it doesn't hurt to do the other guy a favor every now and then when it does not hurt your client. Mm-hmm. you know, you come to me or you need a continuance. You know, you've got a legitimate reason. Or sometimes not legitimate, you didn't get ready. You know, the thing to do, if you possibly can, is agree. Say, yeah, we'll get another date, because one of these days, my ox may be in the ditch, and I may be wanting something from you. You know, and as long as you can do that and not hurt your client, that's the only way to do it.
There's some who say that the license to practice law carries with it a fairly substantial responsibility to give back. How do you feel about that?
Oh, I do. I feel that way. I've done a lot of free work in my time. I'm serious. I'm not bragging. I'm just telling you. And I think we're obligated to represent people if we have the time or can take the time, who are not able to pay us really what we otherwise would charge or expect, and whom we think deserve a good defense. And even in civil cases where you see somebody that's been mistreated and maybe can't afford to pay a top lawyer. And if you got the time, I think you're obligated to do those things.
I know you've been involved in a lot of community activities and a lot of political activities. You've indicated earlier that you came from strong Democratic roots in your family, and I know that you've followed through with that. You were active in Democratic politics in Murray County over the years.
Yeah, I've never run for public office, but I've been real active in Democratic politics since I got here. I was campaign manager for Estes Kefauver when he ran in 54, I think, or 58, twice. And I was campaign manager in this county for Adlai Stevenson. I don't know if you remember Ms.
Yes, sir.
Stevenson or not. That was, I think, the early 60s. And I was campaign manager in about 5 counties for John J. Hooker, who's my buddy, when he ran against Buford Ellington. He and I have been good friends for a long time, since we were. Tell you a real short, funny story about John Jay. I'm in Centerville. I'm 12 years old, 13. They had one tennis court in Centerville. Me and my friend Jim Walker, who runs the bank down there now, the older men taught us to play tennis. We thought we were pretty good. So I looked in the Tennesseans in July. They're having the Nashville City Tennis Tournament, Belle Meade Country Club. Never been there. I said, Jim, let's enter. It's full ages like 10 to 12, 12 to 14. You know how it was. Jim wouldn't go. He said, no. He said, I'm just not going to do that. I said, oh, I'm going to enter. So I entered, got a letter back, be at the Belle Meade Club at 2 o'clock on July whatever. Caught the Ladd bus. There was a bus that ran from Centerville to Nashville twice a day. Caught the Ladd bus and got off downtown at the bus station was down on Commerce then. Got off there and walked up to church looking for the Belle Meade bus. And I bet I hadn't been to Nashville 5 times in my life, and never did come by. But finally, I got up enough nerve to ask a lady, you're on the wrong corner, go down to the Tulane Hotel. That's down on 8th then. Sure enough, here comes the Belle Meade bus. By then, the match, it was past 2 o'clock when I get there. The match is over. I think I'm 12 or 13. Had my tennis racket, my long white pants. Walked up to the tent at the Belle Meade Club where you registered in. She said, but it's too late, the match has been forfeited. You weren't here. This kid standing there, he must have been about 8 or 9 years old. He said, well, he was supposed to play Paul Daniels, and Paul's still here. Said, I'm going to go get him. Said, this boy's come all the way from Centerville. And he went and got him and talked him into playing me anyway. Well, it turned out Daniels was the winner of my division. He just whipped me good in that match. The boy that went and got him was John J. Hooker.
Right.
And years later, I met him in law school. We got to be good friends.
He's become somewhat of a controversial figure. You still close to John Jay?
Oh, yeah. You know, that doesn't bother me. Talking about politics, my wife is the chair for the Democratic Party in Murray County and is also, Bredesen just appointed her to the Board of Cosmetology.
You've been involved in other activities. You mentioned a while ago that you served on the Board of Professional Responsibility. You were, I don't remember exactly when that came into being, but I know I've seen your name on several opinions, ethics opinions. You were early in the process.
Yeah, I got on in '84. You serve a 6-year term and got off in '90. It was a great experience. I learned a lot and met a lot of. I was on there with Bill Willis and several, Cecil Brandstetter, and a lawyer from Chattanooga that I just admired so much, and Max Bonner, great fellow.
Well, the lawyers you mentioned, interestingly, have rather diverse client bases. Bill Willis and Cecil Brandstetter.
Oh, yeah.
Coming together in that environment, tell me about lawyers being able to work together even though their clients have dramatically different interests.
Well, it depends on the individual. It all depends on the individual lawyer. You know, the problem, most clients will listen to their attorneys, most clients. But then you'll find some that won't. I run into that in mediation all the time. But even though they have diverse interests, if the attorneys are gentlemen and trying to cooperate and want to settle or want to work out some suitable agreement that can be done.
How does your background as an advocate, and as you said a while ago, you're a pretty competitive advocate, very successful advocate, how does that meld into being a mediator?
Well, I think it helps a whole lot because in mediation, the key to settling a case is, one, if the parties know who you are and have heard, now I'm talking about the parties, not the lawyers. If the parties know who you are and have heard good things about you, that, you know, he's not only that he's a good lawyer, but you know he's a fair person. If the mediator can ever gain the trust of the parties, like most of mediation cases are automobile accidents. You've got a plaintiff who's never been in court, probably never had a lawyer before. Of course, you've got the defendant who is really the insurance company, the liability carrier. The person you really have to get the trust of is the plaintiff who's never been in court. Probably does not trust lawyers anyway. I'll guarantee you half of them don't trust attorney. Not really, I know, really a little suspicious of their own attorney because they haven't been there before. If you, in the 3 or 4 hours in mediation, if you can get started with them and you get the trust of that party, you are going to settle that case. I've settled them when the lawyer said no, but his client believed what I was talking about and said, settle it anyway. And that's the way it should be. Mediation
is still fairly new in our jurisdiction in Tennessee. It's used a lot. It's used a lot more in some places than in others.
California and Florida, the Supreme Court has a rule that no case can be set for trial unless it's first mediated. Every case. Paul, you wait and see. It may not be in my lifetime. It may be in your lifetime. But eventually, we're going to have a rule in this state that every single case must be mediated before a judge can set a trial date. You watch.
You still find a lot of resistance among the lawyers who come to mediation to the process?
No, I think we're getting converted.
Early on, it was tough. I know it was difficult for me to buy
Well,
into.
nobody likes anything new. That's that's it.
In addition to serving on the Board of Professional Responsibilities, you were involved in the writing of the criminal rules.
Yeah, I was on the Tennessee Criminal Rules Commission in the 80s. I've forgotten when. Rule 35, I brag on myself. I got that one in there. I wrote that rule. It's the Rule 35 of Rules of Criminal Procedure, which provides that after sentencing a defendant, after he's been convicted and he or she and is sentenced, the defendant now has 120 days from the date of sentencing within which to file a motion for the judge to reduce the sentence or change the sentence. It must be filed within 120 days, and there's a federal rule close to it. And it gives the judge an opportunity that if something has come up or he learned something about the defendant that he didn't know about at the time of the sentencing, it gives him a chance to correct and maybe reduce it. And I'm really proud of that because it's been used a lot. And sometimes judges realize that they've been too hard on that defendant and will reduce the sentence.
How do you feel about victim impact statements?
I don't like them. You know, the victims, they exaggerate in those statements. You know, the victim impact statement goes in with the rest of the papers on the sentencing hearing report. A lot of times the victim's trying to get money. I don't trust the victim impact statements.
We revisit periodically in the legislature and in the courts almost consistently the death penalty. What do you feel about the death penalty?
I don't like it.
Do you think it's a deterrent?
No.
Why?
The people who commit murders, there's not 1 in 100 that think about the consequences or what's going to happen or what punishment it's going to be. A great percentage of your murders are crimes of passion. A man kills his wife, the wife kills the husband, they're arguing over a boyfriend or a girlfriend. I mean, all those kind of crimes usually are committed by a person who's never committed a crime before and probably never will again. Now, I'm talking about the family type, girlfriend, boyfriend, husband, wife. Man kills another man because he's going out with his wife, that type thing. Now those are one-shot deals. They're not thinking about the death penalty when they commit those acts. And these guys that are hired to kill, they are not thinking about the death penalty. And these fellas that kill during robberies or that type thing, or rapes, they are not thinking about the death. I don't think the death penalty is any deterrence to anybody.
What about it as a form of punishment to the person who commits the act?
I think that's wrong. We get back to religion with me on that. See, I just don't think if you asked that question to Jesus Christ, you'd know what the answer was. So, it's wrong.
You've been given a lot of awards, been recognized for your success as a citizen and as a lawyer and as a trial lawyer. I know that you have been invited to and have joined a number of years ago the American College of Trial Lawyers. What does that mean to you?
Well, of course, I guess that's the biggest award it's the most satisfying award I've ever got. You know, to get in the American College, you have to be nominated by somebody, and you never know who nominates you. It's all a secret type thing, and then they vote on you. The committee votes on you, and they send out to all the other members in your state, they send out a slip where they can vote, mark yes or no on that client, on that nominee. And I felt real I was so honored to have that. And I was honored to be on the board of professional responsibility. I felt real good about being, in fact, Bill Harbison called me. He was Supreme Court judge then, and said, "Would you be on the board, and can we appoint you to the board?" And of course I said yes, but I bragged on that.
We've talked a bit about you, quite a lot, as a matter of fact, about your criminal practice, and you mentioned a while ago that that's probably only about half of your practice. You've had a very broad and diverse civil practice over the years as well, sometimes even getting to going back home to Hickman County.
Well, I've always done really well in Hickman County. I used to go down there a lot, try cases. My firm, we defended all state. We had all state in about 9 or 10 counties. Prior to that, we'd had State Farm. And we had Hickman County. I'll never forget, I went down there, it's been 30 years ago. I must have been in my 40s then. And defended a case for, no, I was the plaintiff. I was the plaintiff in this case. And a lawyer from Nashville, I think it was Larry Estes, but I'm not real sure, was defending for some liability carrier. And I would know about half the jury panel. And the judge had all 12 in the box, 12, and the lawyer, he asked the usual question, "Does anybody know Mr. Colley?" You always ask that. "Do you know the other lawyer?" And 6 of them held up their hands. And, well, it just shocked this fellow because he thought I was from Columbia. And he started asking each one how they knew me. And he got to Miss Louise Duncan. She must have been 65 or 70 then. She'd been my Sunday school teacher, and I'd been her paper boy. And in the summertime when I was in college, I was a substitute mail carrier from the city of Centerville, town of Centerville, door to door, you know. And I knew just about everybody back in that era. So she says to this lawyer, "Well, I've known him since he was a child. I've known his family all my life. I was his Sunday school teacher at the Methodist Church. And beside that, he's the best paper boy we ever had." So that's one of the highest compliments I've ever received in my life, is I was the best paper boy. Anyway, we settled that case. We didn't go much further. Denny Bell, I'll tell you a real funny story about that. Denmark Bell was the judge in that case. He had that circuit. He and I were in law school together. He was number one scholar in our class. And Denny has a real dry wit, real dry sense of humor. And 2 or 3 years later, I'm down there trying another case. And there's a lawyer from Columbia, Ed Law Wells, in it, and a lawyer from Nashville, and I can't remember who he was. Anyway, this lawyer from Nashville was a big-time lawyer, too. Wasn't Randy Kennard, it was somebody else. Anyhow, that lawyer says, "Judge, can we have a little conference before we start that might help us in moving the case along?" We go back in the judge's office. This Nashville lawyer says, "Well, we shouldn't have any trouble picking the jury. We're all from out of town." And Judge Bell looks him straight in the eye and didn't crack a smile and said, "Well, Mr. So-and-so said, you may be from out of town. Mr. Lawwell may be from out of town, but Jerry's the best paper boy we ever had." This lawyer didn't have a clue what Bell was talking about. I mean, he didn't. It was really bad news.
You mentioned a while ago our great mutual friend Bill Keaton from Hohenwolf, and Mr. Bill has been the subject of one of these interviews earlier that Landis Turner did with him. You told me the other day about a little matter that you got involved in. Mr. Keaton was involved in. Judge Gill, I believe, down there.
Let me tell you about Keaton. Keaton is one of my, when I rate the lawyers, and I believe it or not, and he's a country lawyer from home, he's one of my top 5 lawyers that I've ever dealt with. I'm talking about trial lawyers, nothing but trial lawyers. He's third or fourth in there.
I don't think he's ever
Mr.
lost.
Hooker's number one. But anyway, I get a call from a guy that I'd gone to school with in Hickman County, who lived in Perry County, who had been involved in a property line lawsuit. And he'd been represented by a lawyer from Centerville. Keaton represented the other. He's a big property line
Oh, he's
lawyer.
never lost one, I don't think. He's magnificent property line lawsuit.
And
lawyer.
he represented, and Judge Wiley Smith was the judge. Well, Keaton could get most anything he wanted from Wiley Smith. I promise that. And Wiley Smith had decided for Keaton's client, given the several acres to his client, including the barn. And Byron King was the man who lost, and he called me and said he wanted to appeal it. I said, well, I don't appeal cases. He said, I haven't tried. But he said, well, I've got to have somebody appeal it. Judge Sam Gilreath, who was the dean of the Cumberland Law School for years, had just retired and gone to work with Alf McFarland, who was the brother of Lon McFarland that I worked with. And Judge Gilreath, everybody that went to Cumberland thought Judge Gilreath was Jesus. I promise you, you talk to any of those, and they were all, at one time, nearly every judge on the Court of Appeals, the Supreme Court, was a Cumberland graduate. I promise. Well, anyway, I sent him to Sam Gilreath and never heard from him until about 6 months later. I get a call one day from Keaton, and he and I are close. But he called me a bad name over the phone, and I can't say it on this tape. He says, Colley, you know how he talks. You blankety blank. I said, what have I done? He said, you sent Byron King to see Sam Gilreath. That's what you did. I said, how did you know? He said, I found out about that. He says, you know what happened? I said, no, what happened? He said, Gilreath appealed that case to the Court of Appeals, and back then Perry County was in the Jackson, West Tennessee division. They had to go to Jackson, now it's Nashville. Says, we went to Jackson to argue that case, and said, they called him Judge. Judge Gilreath was late. Said the 3 judges of the Court of Appeals, they were already on the bench. He walked in about 10 minutes late. Said when he walked in, they all stood up. And he lost the case. He told me, he said, I knew I'd had it when that happened.
Well, civil practice, of course, is a good way to make a living. You've got some other cases that you've tried that have been memorable ones to you. Tell us about that.
Well, let me tell you about, now this wouldn't happen, but back when I'd first started, I'd been practicing law about 10 years. We had State Farm. I'm defending State Farm insured in an automobile accident in Giles County. I think Hal Forrester had the plaintiff. And my client was an older retired school teacher named Miss Pearlie Mae somebody. Everybody in Giles County knew her. This has been 30, 40 years ago. And we finally picked a jury. No question, Miss Pearlie Mae ran into the rear of this car and the plaintiff was suing. The jury goes out. We tried it in a day. They come back about 4 o'clock and they say, Judge, we want to go home and come back tomorrow. Well, we thought that's a little unusual because no question about liability. We later found out that they went in the jury room and the first thing that was said was, I wonder how much insurance Miss Pearlie Mae's got. Wonder what her limits are. We don't want to hurt Miss Pearlie Mae. They nearly all knew her. And one of them said, well, I know who her insurance agent is. It's J.P. Colvin. He's the State Farm agent in Pulaski. We found all this out later. And he says, you know, if we told the judge we had wanted to come back in the morning, he let us do that. And I'll call J.P. tonight and find out how much her coverage is. So sure enough, when they came back that morning, at 9 o'clock, in 15 minutes, they walked out of the jury room with a verdict. And they brought a verdict back for $10,000. Well, this is so long ago that the limits, the minimum limits back then was 5,000, 10,000. 5 for any one injury, 10 for the whole thing. And when they said $10,000, of course, all Miss Pearlie Mae had was the fives, because one injury. Well, she starts crying right there at the table. And this juror, one of the who knew her, came over to us and said, "Miss Pearlie Mae, what's wrong? Why are you crying? We didn't hurt you on this." "Oh, Bill, yes, you did." Said, "I've only got $5,000. He said, "Oh, my God, what have we done?" So he goes back and gets to Judge Ingram and tells him, of course, Judge Ingram likes to have a fit right there when he told him that they had called up and got. So Judge Ingram set the verdict aside, of course. And, of course, then I settled the case for the $5,000. But things like that don't happen anymore.
You tried a lot of cases in front of Judge Ingram. I think he was on the bench here, what, 41 years? And was the only judge in the circuit for most of that time, wasn't he?
Oh, yeah.
You also did a lot of practice in other counties in Middle Tennessee and some other places. Tell us a little bit about the differences in practice between, say, out here in the hinterlands and in Nashville.
Well, there's a great difference in county to county, especially one in amount to be awarded that a jury will give. You go to Wayne and Perry and Lewis, the smaller counties, juries don't give the verdicts the amounts that they will in some of these larger counties. And in criminal cases, especially, I'll get back to murder cases. You go to a county like Wayne or Perry or Lewis or some of these, and the criminal defense attorney has a big advantage in those counties in murder cases, because if you can prove any kind of defense in these rural counties, you get a culture that's, well, I'm not going to say redneck, that's not the good word for it, but that believe in self-defense and I'll take care of I've got a gun, I take care of myself. In these extremely rural counties, you get that, and it's great for a defense lawyer to go into those counties. Now you get into Murray County, it's become very cosmopolitan now and grown, you know, and a lot of white-collar people on the jury. It's hard. It's a lot more difficult for the criminal defense lawyer to get not guilty verdicts now in this county and some of the surrounding counties than it was when I started. I had a great big advantage, great big.
How do you deal with picking juries in so many different areas? As you say, they're different folks. They come from different backgrounds. How do you pick a jury in, say, Perry County as opposed to Murray County or Nashville?
Well, it all depends on the case. You know, it's a civil case or a criminal case. And I shouldn't say this. In a criminal case, you would want, at least I usually want, the lower, I don't want the real high income executive type, vice president of the bank or supervisor at the plant, you know. I want the ordinary, everyday, blue-collar worker, if I can get it. Don't want any school teachers. They go in the jury room, try to tell everybody what to do. See, that's all their whole life is telling students. Don't want any preachers either. In any type case, they'll go in and try to tell everybody what to do. You know, that's all they've done their whole life is preach to the audience there. Civil suit, though, if you're talking about big money, you might want some folks that are used to big money. And you want the upper echelon there, because you go in some of these small counties, low income, you take $10,000 or $20,000, that's more than that guy's ever heard of, I mean, or ever had in his hands. So it just varies.
You said it a while ago that juries like to do good things for people that they like.
Mm-hmm.
But what is a good thing? The difference might be.
Well, in civil suits, if they like the plaintiff, they're going to give him all he can under the facts. You know, they have a great range they can pick. If they don't like the plaintiff, he's going to get very little. Tried a case not long, well, it's been 10, 15 years ago. I had an 18-year-old boy rear-ended a woman at a stoplight. Did a little damage to the back end. She claimed she was hurt all over. I ran up $6,000, $7,000 in medical bills. She gets on the stand. She just is, everything hurts, and it's, you know, just on and on. They didn't like her. Now, absolute liability. My kid rear-ended her. I was representing his insurance carrier. Jury goes out, finds in favor of my client. Didn't give her a nickel. Of course, the judge said it decides that she's going to have to get something. They did not like that lady. And you can see it over and over and over again.
Many lawsuits as you've tried over the years, and I know for a fact that you've had many weeks when you would have 2 or 3 jury trials in the same week.
Well, too.
How do you deal with that from a work ethic standpoint? How do you have time to prepare?
Well, you just don't. You just go do it. See, when I was doing that kind of work, it was before they put in these new rules where you didn't have to answer all these interrogatories and depositions and stuff. You could just get at it. You see what I mean? I mean, you could try 2 or 3 a week and be all right.
Of course, with Judge Ingram, the traveling circus used to follow him around, didn't you? Around the circuit and just go wherever he was.
Right.
Have you ever thought about how it would have been if you'd practiced in Nashville or Knoxville or Chattanooga as opposed to
I had an offer from the Kramer firm in Knoxville back in '51, and they offered me $300 a month. I had already been hired by Mr. McFarland, but before he hired me, I had an appointment to go see him. And Mr. McFarland started me out at $165 a month. And I was smart enough to take that as opposed to going to Knoxville, to a big city, which I wouldn't like.
Well, your firm was a pretty big rural firm, McFarland, Colley, Blank, and Jack. Y'all were pretty stout.
When it was McFarland and Colley, then it got to be McFarland and Blank and Jack, and that's Ed Blank and Billy Jack. And in the meantime, we had Bill Kane and Bob Jones in there, which never were partners, but they stayed with us a year or 2 each time.
I remember that as being probably the most prominent firm. That was back before a lot of the Nashville firms started putting offices in Murray County. But you all were the biggest firm in Murray County when I first started practicing law.
Right.
And had the reputation as such.
You know, talking about lawyers, though, when I started practicing law, there were very few women lawyers. In Vanderbilt Law School, in my in the whole law school, I guess there were 200 people, students in the law school. There were 3 girls when I graduated in '51. And my first encounter with a woman lawyer was in federal court with Frank Gray, judge. And my client was Frakes Electric Company, and they'd been sued by the Department of Labor for, under the Wage and Hour Act. And the lawyer for the Department of Labor, there was no jury. Lawyer for the Department of Labor was a woman, Ruth, I think her last name was Spears or Shields. First lawsuit she'd ever tried. Good-looking red-headed girl, about 27 or 8. The older lawyer for the Department of Labor came along with her. And she was cross-examining my client. And she asked questions that weren't relevant at all. And I played along, and finally I objected. Judge Gray says, "It's about time you objected." Said, Miss Shields says, "How's that relevant?" And he said, re-ask the question. So she did it again, and she did it wrong again, and 2 or 3 times. And he got upset with her. He said, "Now, Miss Shields, I know that's not relevant. Now, don't ask that anymore. If you can't tell me why it's relevant. Kind of fussing at her, and she started swaying, and she fainted dead away right there in front of the judge. Well, this lawyer with her caught her before she hit the floor. I mean, she was out. We picked her up and laid her out on the front bench there behind the railing. And she finally came through it, too. And Judge Gray comes off the bench with his robes flying. He's running down there. And says, "Oh, Miss Shields, I'm so sorry. I'm so sorry I've done this." Well, from then on, she revived and we continued with the trial. From then on, she got everything she wanted in that case. I promise. It was bad. Well, that's the thing, I always question whether they should allow women to practice law anyway, that kind of, I'm kidding on that one. But I told her, she and I got to be real good friends. She was finally the head of the whole Department of Labor law office for the whole Southeast. And we left that courtroom that day, and I said, "Well, Ruth, you sure have played a trick on me. This is some way to win a lawsuit." But she really fainted. She wasn't kidding.
You've got some notes there that you're referring to, and I know that since you and I talked the other day, you made some additional notes. What else you got there that...
Well, I thought about it after we left the other day. I had a client in a criminal case commit suicide during the trial. It was really sad. And this is back, I'm going to say, in the 60s. And it was, my client was a deputy sheriff. And the other defendant, there were two defendants, was a city policeman in Spring Hill. And they had chased, a young boy went through Spring Hill going real fast. And they were together in the same car for some reason. They chased him all the way to Franklin. Finally got stopped in Franklin at that 5 points, they call it. There's a big intersection, 5 streets there. Big crowd gathered around. They finally got him in the car and took him back to Murray County Jail. Well, a lot of people got mad that saw it. They say that the officers abused him and hit him. He ended up, after he got out of the Murray County Jail, paid a fine or whatever, he went back to Franklin and charged these two officers with assault and battery. That's what they called it then. And I represented Bill Hill. He was one of the officers, and Robin Courtney and Sam Kennedy represented the other officer. We had a trial in that same courtroom that the Bennett trial was. Packed. You would not believe the trial, the crowd there, over this misdemeanor. And on the second, Judge Wally Smith was the judge. Alonzo Bates was the prosecutor, and he was tough prosecutor. Second day of the trial, my client Bill Hill had been in the penitentiary when he was in his 20s. He was about 60-something then. And he'd been there in the pen, I think he served 2 years for something, and a real bad experience for him. The second day of the trial, we were in the courtroom, and the clerk said, "Come in here, you've got a phone call in the morning." I went to the phone. It was about 9:15. Court started at 9. And it was the sheriff of Murray County telling me that Bill Hill had killed himself at 8 o'clock that morning rather than come back to Franklin to finish that trial. And it was just a blow. And we went into, I went into Judge Smith's office and told him that. I said, "I'm going to ask for a mistrial." He said, "Well, we'll take that up." So 9 o'clock he gets on the bench, and I said, "Judge, we'd like to ask for a mistrial here. One of the defendants is dead, and we can reset the case and start it with the other." "Oh no, we're going to try the one that's living." So we went on. And we walked out of there. Back then, the jury set the punishment. and they didn't like what Smith had done, Judge Smith had done. They could set a fine. It was a misdemeanor, so they could set a fine or jail time, or both. And they gave the other officer a $300 fine and no jail time. So we walked out. But that's the only time I've ever had anything like that take place.
You have some grandchildren.
I sure do.
If you were able to guide them, and you probably will have some input, would you encourage them to go into the law?
Depending on the personality. I've got one grandchild, one of John's son, that's about 7 or 8 now. He probably would fit. And he has a daughter that she's about 6. She might. But he's got another little girl that would. I told my daughter Sarah not to do it, that she's the one with CNN now. And there were so many young people getting out of law school, you know, and a lot of them couldn't find jobs. And it may still be that way. I mean, not good jobs. And she said, well, I'm going anyway, Dad. He said, even if I have to borrow the money. Of course, I went ahead and paid. And I'm sure she was right and I was wrong, because it's turned out real well.
I've got 2 more questions, and you probably don't believe that. I've never had a judge believe it, but I'm going to say it anyway. So the second to the last, is there anything you wish I'd asked you that you'd like to tell us about?
Well, no, not really. I don't want to take up a lot of your time, but when I was in Hickman County schools, graduated from the 8th grade. This has been, let's see, that'd have to be around 1940, 41, somewhere in there. Graduation from the 8th grade back then was a big thing. A lot of kids didn't go on. Mr. Willie Edwards was the principal of Hickman County High School. Old bachelor, tough. You didn't even talk in the halls. He came to the graduation, and Jim Walker, my friend I was telling you about, was the valedictorian and I was the salutatorian. We had to make a little speech. Mr. Edwards comes around after it's over, says, Jim, Jerry, said we're going to have a debate club next year in the high school and you're going to be in it. Didn't give you the choice. You're going to be in when you had to be in it. Never had one before. The ward started. It's about 41, I think, maybe. And the subject for the debate, you know, affirmative and negative, was something about the draft. We got ready for it because the big debate tournament was at Austin P. State College in Clarksville. And we were in the same district with Davidson County and Nashville schools and Clarksville, Dixon, Centerville, about 8 or 10 schools. Well, we had to go over there. It started at 9 o'clock. It's about an hour and a half from Centerville to Clarksville. I've had a suit. Jim had a suit. And I was on, there was a girl named Beth Ammons, and I were together, and Jim and Ruth McCord were together, affirmative, negative. Meet me at the high school at 7 o'clock. We get to high school at 7 o'clock, and remember the ward started. He had a black 37 Ford coupe. He had raised up the lid of the trunk and put a blanket in there. It was a big trunk. You know what those coupes look like that. Raised up the lid, said, now you and Jim sit back here, and Ruth and Beth are going to sit in front with me. It was just a one-seater, you know. We rode all the way to Clarksville. It was cool that April morning, too. All the way to Clarksville, sitting in that trunk with the lid up. Folks would drive up behind us. And, you know, we drive up in front of the Austin P. administration building, everybody just looking. We hop out of that trunk. I want you to know, Jim and Ruth won that whole damn thing. They beat all the Nashville schools, every one of them. And Beth and I went back the next year, and we did it. And you got the trophy. If you did it 3 years in a row, you get the trophy. And Mr. Edwards is going to send Jim and I together back the next year. He's going to put us together and really have the big shot at it. He wanted that trophy. Jim's parents sent him off to Georgia Military Academy. And I got with, I've forgotten who, we ran second. But back then, you know, the discipline was great. It's changed so much.
Jerry, it's been said that if you don't have right much of an ego, you're not going to go very far, particularly as a trial lawyer. What do you want to be remembered for?
Well, I guess I'd like to be, if somebody said, well, you know, Jerry Colley was a real good trial lawyer. He was fair. He was honest. And he did not mistreat the client or the other lawyers.
Jerry Colley, thank you. It's been a privilege to be here with you today.
Well, I'm honored to be asked.
Well,
my wife couldn't believe it. She said, well, she could believe it too. I'll take that back. But that's all she's talked about since I started getting ready for this.
Well, I'm honored to call you a friend, and as a younger lawyer,
I understand.
Tee-hee, it's been a real pleasure to work with you and against you, and certainly have enjoyed preparing for and doing this today. Thank you.
Thank you.